So my first question to you, class, seeing that you all have knowledge, and you have read the book, and you live in this country. So my first question to you is, real property laws in this country is based on what system of ownership? I'll give you the choices. Is it based on the lien theory system? Is it based on the title theory system? Is it based on the feudal system? Or is it based on the allodial system? You live in this country, right? You should know your rights. I guess you haven't read the book. Let's go to page 132. It's important to understand this concept. Page 132 says, on line 43. Recognize that word? Anybody know what it means? You live in this country, you should know what it means. Yeah, right to own land. You give private individuals the right to own property in this country. The government doesn't own real property in this country. You own it. That's what the allodial system is. The right of private individuals to own real property in this country. What it means, you don't have to be a citizen. You don't have to be a resident. You don't have to be a natural person.
This word right here.
You could be anything and own real property in this country. Very important to understand that. And that's the reason why you protect your property rights. Use whatever means possible to protect your rights. It's called the allodial system. And over time, people try to erode it. People try to erode that system. Slowly, they try to erode it. So, in the allodial system, private individuals, when you own your property, the law gives you these rights. These are what we call your bundle of rights. Very important. And what's the important right you have to your property, guys? Possession. Possession is the most important right you have to your property. English law says you possess your property, you have 9/10 of its ownership. You have 9/10 of its ownership, you remember? You realize that? That's when landlords give possession to tenants. Landlords just care about the tenants, right? Because the tenants are there, yeah, and they have what? Possession. And if the tenant refuses to give the landlord back the possession, what the landlord has to do? They go and toss them out. What do they have to do? Either the tenant give it back voluntarily, or where they have to go? They have to go to court. Right? They have to go to court and file for writ of possession. So possession is one of the most important rights one has to the property. You never give up possession unless you have to. If you give it up, it's very difficult to get it back. And the only two ways you can get it back is if the person give it back to you, or you go to court. There's only two ways. And when you go to court, you have to prove to the court that you're entitled to get it. Right? You're entitled to get it. So what you're going to take to court to show that you're entitled to get it? All those documents that you have to figure out that you grant you ownership. If not, that person who's there is going to stay there for as long as they want to. Possession. Most important of all. I mean the right to occupy. The physical possession of one's property. And the legal possession of one's property. The right of disposition. Disposition means the right to sell, the right to will, the right to give away, the right to pledge, the right to exchange. If you own it, you have the right to sell it. You have the right to give it away. You have the right to exchange it. You have the right to pledge it. That's what we do in many cases. We sell, we leave a will, we go and pledge it for money, we exchange it for something else. That's all right. It's called one's right of disposition. The right to sell, will, exchange, give away, or pledge. Then we have the right of enjoyment. It's called quiet enjoyment. And quiet enjoyment means has nothing to do with noise. It means you have peaceful possession of your property. Once you own it, you have peaceful possession. And no one is going to come and take those rights away from you unless they have to. Unless you give it up voluntarily, or they have the right to take it away from you. It's called, they have the right of enjoyment. It's called quiet enjoyment. And quiet enjoyment means peaceful possession. Peaceful possession. Keyword, peaceful possession. Have the right to be there peacefully. No one is going to take your rights away from you. Then we have the right of exclusion. Exclusion means you have the right to dictate who should come to your property and who should not come to your property. And the one who should not come to your property, showed up on your property, you have the right to defend your property. Goes back to the old castle law. A man's home is his castle. And you have all the right to defend your castle and use every means possible. That's why we have a law in the state called stand your ground. What stand your ground says, you have the right to use deadly force. It's a spin-off of this right. One's right of exclusion. You have the right to defend your property and use whatever means possible to do so. Finally, the right of a control. Control means you have the right to use your property as was intended for. Those are ingrained rights in law. It's called your bundle of rights. The owner's bundle of rights. When they acquire ownership, those rights go along with it. Most important of all, right of possession. So when it comes to these rights, and when it comes to real property, the physical component of real property, the most important physical component, class, what's the most important physical component of real property? Starts with the L word, is that love? It's called the land itself. People fight wars for that piece of dirt. People get killed over time for that piece of dirt. The land itself, and the rights that goes along with it. So the physical component of that piece of land, you have the subsurface rights. Anything that flows below it is the landowners. That's the reason why we had the question yesterday in George's portfolio. Who got 5 shares for negotiating an oil lease? Remember that question? And why did George need a real estate license to do so? Because it's part of real property. Mineral rights. Things that flow below the land is all the landowners. Surface rights. Anything that's attached to the land either by nature or artificially. So what does nature attach to the land, guys? The trees. The trees are the landowners. You can cut your tree down. That's why the guy that grows a marijuana plant, he goes to go and say, hey, it's natural. It's mine. I can grow it. But the law says you can grow it, but you can't smoke it. Right? That's the same concept. You have your right. That's the right. It's growing, natural. Right? But law, we pass laws to restrict what you can do. Anything that's attached to it by nature, artificially, you improve the land by a home, you put a fence around the land, it's all yours. And finally, the air rights. The air above the land to a height established by law. Those are all legal rights of ownership when you own one's land. The surface rights, the subsurface rights, air rights. Those all go as part of a package when you own your property, unless you sold for part and have the remaining part that you own. Land abuts water. One has riparian rights. Riparian rights means that you have the rights to the water. Landowner owns the water. And it depends on the body of water that the land abuts. Well, if the land abuts a river or a stream, one has riparian rights. If the land abuts a lake, sea, ocean, gulf, one has littoral rights. So when you read the exam question, and the exam question did not identify the body of water, the overall legal right one has is called riparian. If the question identifies the body of water, then you have to pick either riparian, which is a river, or a stream, or littoral, which is a large body of water. Whatever large body of water, lake, gulf, ocean, sea, these are large bodies of water, then the landowner has littoral rights. So the question worded, and based on how the question is worded, you will have to pick either riparian or littoral. And if the body of water is not identified in the question, the overall right is called riparian. That's the legal rights to the water. Here we have these definitions that the examiners will post questions around. The definition of erosion, the loss of land through a natural force. Natural force, whatever natural force it is, reduces the land mass, it's called erosion. Accretion, opposite to erosion, the increase in land through a natural force. That's the opposite to erosion. So we have these natural forces, whatever the natural force is, increases the land mass. That concept is called accretion. Then we have alluvium. Alluvium means the actual movement of the soil. As the soil is moving, it's called alluvium. And once it settles on a piece of land and increases land mass, it results in accretion. So alluvium basically is the actual movement of the soil, and it settles on another piece of land, increases its land mass. Reliction is somewhat similar to accretion, but reliction basically has to do with receding water. Water recedes, the land mass appears, it's called reliction. So you have a stream that dries up, the river that basically loses its volume, land appears, or lake. These are all concepts of reliction, when you have land mass increases as a result of receding water. So know the difference between accretion and reliction. I know the difference between alluvium and accretion. All different. And the examiners expect you to pick the right answer. Then we have this item that sometimes becomes litigious because it's part of the home, and it's called a fixture. A fixture by nature, it was personal property to the homeowner. When the homeowner goes out and buys it, it's personal. That's the homeowner's piece of property, and takes it and attaches it to the home. It becomes real by attachment. So that item that the homeowner buys, it's personal. So when the homeowner takes that personal property and attaches it to the home, it becomes real by attachment. The homeowner can reverse the process by severing it, and it becomes personal again by severance. So that same item can be part of the home by attachment and become personal again by severance. And that's where the problem is. So when the homeowner is selling that home, and these items are there attached, and the homeowner can reverse the process by making it personal or removing it, then there are arguments. Because in the buyer's mind, those things are part of the home. Those things, because the buyer saw it, and the buyer says, where's that stuff that's attached? Well, it was mine. I severed it. Make it personal again. And there's arguments, like normally we go through. So when there's litigation or disputes concerning this item, and the courts get involved, the court will put the article to a test. And there's 4 tests the courts will use to see if the article has to stay. That means it still continues to be real, or the article can be personal by severance. So the first of the 4 is called the intent of the parties. What were the parties' intention? Well, the only document the court can review to determine the parties' intention are either the listing contract or the sales contract. But if those 2 documents are ambiguous, it's hard to determine. And that's why it's very difficult for courts to determine when written documents are not clear enough. And that's the reason that you have to be careful. Because if those documents are not clear enough and you prepare them, you may end up buying that item as a housewarming gift. Because it's your fault. You did not perform that duty we discussed yesterday in agency law. Remember that duty? Anybody remember that duty if you did not prepare the contract properly? What's that duty called? For those of you who did not have dementia problem this morning. I mentioned it many times that if you don't perform this duty properly, you will never get paid. It's called your skill, care, and diligence. Remember that duty? Your skill, your care, and your diligence and duty you owe to your customer or to your client. And if you don't do it properly, you may end up buying that item, because that's the duty they're gonna sue you on. You did not give me your care, you didn't give me your skill, and you put diligence in the transaction. So you have to take some of that money and buy it as a housewarming gift. So be careful. The relationship between the parties. How are the parties legally related? Well, there's only two relationships you have in law when it comes to this item. You have the seller-buyer relationship, and you have the landlord-tenant relationship. Well, the buyer-seller relationship, well, they go back to that same documents we talked about a moment ago. Listing agreement, sales contract, or implied actions. So the court has to review all this information and try to make a determination. And if things are not clear enough, well, the default is the item basically can be removed to severance. The other relationship is called landlord and tenant relationship. Landlord-tenant means that if you are a tenant in your landlord's property and you put items that are important to you, well, I'm sorry, the landlord says it's mine. It's called landlord's betterments. So those things you put in your landlord's unit or condo, whatever it is that you rent from your landlord, becomes the property of your landlord. You can't take it when you leave. The landlord can insist that you leave it there. People didn't know that. It's called landlord betterments. The only time the landlord cannot make claim to that property is if one is a commercial tenant and one improves the landlord's property by items that are important to the business. And these items are not fixtures. They're called, what are you called, guys?
Trade fixtures.
They're called trade fixtures. Trade fixtures are not fixtures. Fixtures are either real or personal. Trade fixtures by nature are always personal to the tenant. Therefore, when the tenant leaves the premises, the tenant has the right to take it. However, if the tenant is going to sever it, the tenant has to make sure they do not destroy the landlord property in its removal. And if it does, the tenant has to put the landlord's property back to its original condition. And that's the reason tenants sometimes will leave those items, those trade fixtures, because of the damage it may occur. So trade fixtures by nature are always personal property to the tenant. It's never to the landlord. So the tenant has the right to take it away when they decide to terminate or the lease term ends. So fixtures are either real or personal. Trade fixtures by nature are always personal. Then of course we look at how it's to be severed. It's called the method of annexation, the severance of the item. Well, the courts will say, if you have to destroy the property or damage the item is removal, then it has to stay. If there's no damage to the item, and there's no damage to the land, to the owner's property, then it can be removed. So how it's severed has a lot to do if the article has to stay, if the article has to go. And finally, the adaptation of the article. If the article is customized for the home, it has to stay. So those are the tests the courts will use to determine if the article has to stay. That means it continues to be real, or if the articles can be removed where they reverse the nature to make it personal by the act of severance. There's no other court test. Those are the four. The size of the article, the value of the article is of no consequence. These are the four tests the courts will use. There's no others. In the allodial system, when one acquires ownership interest in real property, one acquires an estate or a tenancy. The words are used interchangeably in the exam. Do not let those words confuse you. In some places you use a tenancy, in some cases you use an estate. It doesn't really matter. It's the same meaning. An estate or a tenancy has the same meaning. Do not let the word confuse you. In some questions they put the word estate, in some questions they put the word tenancy. So the definition of these two words, which are the same, is the quantity, the nature, and the extent of one's ownership rights they have in real property. Quantity means how much. Nature means what type. Extent means how long. That's what an estate or a tenancy means. Quantity, how much. Nature, what type. Extent means how long. So when you read the question, you see the word estate or a tenancy, well, it'll confuse you. It means the same. So when it comes to the allodial system, there are only two general types of estates. Only two. Or two general types of tenancies. There are only two. The first of the two is called a freehold estate or a freehold tenancy. A freehold estate is an estate for an unknown duration. The duration of that tenancy or that estate is unknown. It'll go on forever, or it goes on for the life of the life tenant. It's a freehold estate, an estate for an unknown duration. And there's only two. And the first of the two, and the highest, most comprehensive ownership one can have, is called fee simple. It's a fee simple estate. A fee simple estate is an estate that has an unknown duration that goes on forever. It survives the death of the owner. It survives the death of the owner. That's why when somebody owns a fee estate or a fee simple estate, you have the word, the estate of the deceased. What it means, the deceased's estate is controlled by the deceased. The deceased controls the estate from death. And there's one document that does so. And the most powerful document one can leave before they go to the hereinafter is called your will. It's called your will. The most powerful of all documents one can leave is before they go where they're going. It's called a will. You have the right to dictate who should get it and what you should do with it. That's the right every court in this land will recognize. That's why they go for the last will and testament of the deceased. And everyone who dies have an estate. And that's the reason we had these questions yesterday, that the personal representative can dispose of the estate of the deceased, and they don't need a real estate license, because they were appointed by will to do so. The person appoints them. Even in death, they appoint them. The person dies, hey, you still gotta honor my will. And that's the most powerful document. The lesser form of freehold is still an unknown duration. It's called a life estate. A life estate basically is an estate that doesn't survive death. A fee simple estate survives death. A life estate does not survive death. It's unknown because no one knows when the big guy upstairs or the big guy downstairs is going to call you. Right? Don't forget, either you go up or you go down. You don't know where you're going. Hopefully you're going up. Right? You all pray to go up. But sometimes the guy downstairs is more powerful than the guy upstairs. So, a life estate basically is for the person's life. It does not survive death. Therefore, seeing that it does not survive death, and in the allodial system, property rights must be with private individuals, can be by themselves. Therefore, this estate cannot stand alone. A life estate must be attached to one of these two. And the first of the two is called an estate in reversion, where those property rights will revert back to the original owner. Or the original owner says, I do not want these rights, I want these rights to go to a third party. Then it will be attached to the remainder's estate. One of these two will be part of a life estate. One more time, a life estate cannot stand alone. It has to be attached to either a reversionary estate or a remainder's estate. A fee simple estate can stand alone because it survives death. A life estate cannot because it doesn't survive death. Therefore, it has to be attached. From inception, it has to be attached. So remember that for a state exam question. It's called an estate in reversion. They test you on that. They test you on a reversionary estate. It's one of the questions according to my Central Intelligence Agency. Right. It's called a reversionary estate. Estate that reverts back to the original owner when the life tenant passes away. So those are your freehold estates. And freehold estates are estates for an unknown duration. That means it has no timeline, and you have the only two. You have the fee simple, the highest estate one can have, real property, and you have the life estate, which has to be attached to either estate in reversion or a remainder's estate. One of the two has to be attached to that life estate. Then we have the estates that for known durations. It's called a non-freehold. Non-freehold means it has a timeline. It has a timeline attached to it. And the only non-freehold estate we have is called an estate for years, or a tenancy for years. An estate for years is a leasehold estate or a non-freehold estate that have a definite timeline. It has a definite timeline. And the document that creates this estate is called a lease. The lease creates the estate. And that's the reason we're not allowed to prepare leases if you're a licensee. The only two people who can prepare leases, either the owner themselves, because it's their right to do whatever they want, or a practicing attorney. That's practicing law. Because preparing a lease is practicing law. And therefore, we are not allowed to prepare leases. So, that's called an estate or a tenancy for years. There's two other leasehold estates, but they don't have timelines to it. You have an estate at will, and you have an estate at sufferance. They don't have timelines to them. But the one that has a definite timeline is called an estate for years. But there's other two, there are two other non-freehold estates where they don't have a signed lease, just having possession of the owner's property. And that creates an estate, called an estate at will, or an estate at sufferance. So when it comes to the fee simple estate, in the freehold categories of estates, there are four. There are four fee simple estates. The highest, most comprehensive ownership rights one can have in real property. The highest is fee simple. And it depends how you have ownership in fee. There's four. And the first of the four is called a tenancy or an estate in severalty. There's a fee estate that's owned by one person. If owned by yourself, it's called an estate in severalty. Severalty means one owner. One owner, single person, divorced person, unmarried individual, or a widow or widower, a surviving spouse. Own it by yourself. You have a severalty estate. If the estate is owned by two or more individuals, these are the three fee estates that can be formed. And the first is called a joint estate. It's a fee estate that's owned by two or more individuals. Or there's an estate in common. It's a fee estate that's owned by two or more individuals. Or an estate by the entireties. It's a fee estate only owned by husband and wife. These are all comprehensive estates. In fee, either in severalty, in joint, in common, by the entireties. There are four. Can't get any higher estates than these four. They're all fee estates in the freehold classification. So, when two or more individuals own the estate, these unities of title are always present. Two or more individuals. These unities are always there. And there are four unities of title. And the first of the four is called a unity of possession. Keyword, possession. Again, one of those most important legal rights one has to the property. Well, possession in any estate is undivided. If you own it to someone else, own it to your spouse, it's undivided. That means the owner is not restricted to any part of the estate. If I own 10% of an estate, I have the possession of all of it. It's called an undivided possession. I'm not restricted to 10% of the estate. I'm not restricted to the corner by the bathroom. That's the only corner that you can possess. I have the right to possess the whole estate. So possession is undivided. Interest can be equal or unequal interest. Owners can have equal interest in the estate, or they can have unequal interest in the estate. They can acquire it at the same time or at different times. It's called the unity of time. Owners can go out there and acquire it at the same time together, or they can go out and acquire it at different times. That's called the unity of time. And the unity of title means the owners can have deeds individually, or they can be all on one deed. So the document that grants ownership, all the names can be on one document, or they can have individual documents for their percentage ownership. It's called the unity of title. These four unities are always present when two or more individuals goes out and acquires ownership interest in real property. It's always there. So when it comes to a joint estate, which is a fee estate, a joint estate These unities are equal in the same. They are equal unities. If you have 2 people, they have equal unities. You have 10 people, you all have equal unities. Equal unities means that everyone has equal ownership. No one has more ownership than the other. They have equal ownership. And in this type of estate, they all agree together, when they go out and acquire ownership, that they would not make it part of their will. They would not make their portion of the estate part of their will. They agree up front that each of them will have the full and legal right of survivorship. That means they agree up front that they will not make it part of their will. They have all the right to sell if they want to, but they don't have the right to will, because they agree up front when they acquire the ownership that they will survive each other. And the one who survives the other is the one who's going to get that deceased's share. So that is an agreement up front. They all agree that we're going to have this estate by ourselves, and each of us have the full and legal right of survivorship. And that makes it a joint estate. If they don't have that agreement up front, it's not a joint estate. They must have that agreement. They can't wait until they die. They must have it up front. So look, we can acquire this estate under this type of ownership, and we all agree that we have this legal right of survivorship. And in order to make sure that we agree, we'll make it part of the deed. The clause in the deed will say that each owner has the full and legal right of survivorship. So when that owner passes away, that owner's share goes to the others. They don't go according to a will. So the heirs of that person can't come up and say, hey, where's the portion? They can go and challenge that right, because it's already agreed to while the person is alive. Are we clear? That's how it becomes a joint estate. It must be there up front. If it's not there up front, it's not a joint estate. It's an estate in common. That makes it a joint estate. You can have all unities of title equal and same, but the persons have to agree up front that they will never make it part of their will, and they have it in writing. It's part of that deed. That will say that each owner has the full and legal right of survivorship. So nobody can challenge.
What happens to the last survivor?
Well, that he has by himself. So you never go hunting and fishing with those people. No, you have an estate and severalty, only by yourself. Yeah. The last one, it's like the Survivor Island. Have you seen the reality show? Who left on the island gets all the benefits. Right? His estate gets it. His will. No. Right? The person who lives the longest, they will have the total estate. And they own it in severalty. Which means if I own it in severalty, I can make it part of my will. Not that difficult, right? The last person standing is the last person getting the total estate. But they have to agree with it up front. They can't agree with it when they have ownership. So the day they acquire ownership, that document that grants them ownership must have these magical words. Each owner has the full and legal right of survivorship. And this is a joint estate, and that's what the law will recognize. So nobody can come and challenge it by a will. They can't go to court and say, hey, where's my family share? It owns it. Hey, see, he said, give it to me. It's a joint estate. We agree with it up front when we acquire ownership, not on the date of death. You can't agree to it on the date of death. It's already ingrained in law. Question. Which of the following is the most comprehensive estate? My gosh, you guys know the question. It's very easy. We're doing it right now.
Life estate?
No, not a life estate. A joint estate. Most comprehensive. It's a fee estate. A life estate is not comprehensive. You only have it as long as you're alive. A joint estate, the last one standing, have the total estate in fee. It's a fee estate. A life estate is a life estate. It's just an estate in common, another comprehensive. Estate in severalty, it's another. All the fee estates are comprehensive estates. That's the highest, most comprehensive one can have. A tenancy in common or an estate in common they agree up front that they will make it part of the will. And that's the reason you can have all the unities of title. They could be equal unities or unequal unities, but they have the right of inheritability. Each owner says, I will want to make it part of my will because I want to pass it to my family or my whatever, whosoever want to, my beneficiaries. So they agree up front, they will make it part of their will. So it's an upfront agreement. We all go out there and acquire it as in common. Keyword, in common. So that means every owner controls their own part of the estate. Joint means you're together. In common means you are apart. Right? You have ownership interest, but you control it individually. Whatever ownership interest one has in our property. So each owner have the right to make it part of the will. So in a joint estate, there's no part of a will because they agree up front. They'll have survivorship. In this, they don't have survivorship. They have the right of inheritability. That's the word they use in law. It's called the right of inheritability. That means each owner have the right to make it part of their will. So whatever ownership interest is there, and the owner have a will, it goes according to the will. And if there's no will, well, there's a law that will govern it. It's called the law of descent and distribution, where the legal heirs will go and they claim whatever portion that the deceased owns. So that's the difference between a joint estate and an estate in common. One has survivorship, goes according basically to the remaining owners. The other goes according to the deceased as well. Big difference between the two. So when one goes and acquires ownership interest, they have to make a decision. Do I want it as a joint estate with my people, or do I want it in common with my people? So that's the choice people have to make. That's why we cannot advise them how they should take ownership. You have to refer them to an attorney. Let the attorney advise them how these forms of ownership will affect them. You sure? Yeah, that's what you want. Well, the other person wanted something different. Tells you the entireties. Entireties only mean husband and wife. And the unities of title are 100% each. Keywords, unities of title are 100% each. And the reason is 100% each because the property belongs to the marriage. So neither spouse can sell, nor neither spouse can make it part of their will. Because when people go out there, and you will know this, if you don't know, I can just give you some knowledge this morning. When you go out there and say the magic words, I do, remember that word? You automatically becomes half a person with your spouse. You become half a person with your spouse. You're half a man and half a woman.
What if you have the property before you're married? You're married.
Because it just becomes su casa too.
I don't like that.
So the property belongs to the marriage. So neither spouse can make it part of their will, or they can sell it individually. They have to do it simultaneously. Survivorship is implied. That means you don't have to know the word survivorship doesn't need to be in the deed. Because once you say by the entireties, it belongs to the marriage. So the unities of title are 100% each. And that's the reason they say those words, right? Till death do us part. Remember those words? What does the words mean? Those powerful words. Till death do us part means when one spouse passes away, the surviving spouse gets the whole estate.